Good morning, good afternoon, or good evening, as the case may be, depending on when you are listening to this recorded webinar. I am pleased to present today to the constituencies of IREM, NARPM, NMHC, and NAA. The COVID-19 pandemic has had a seismic impact throughout the world in all aspects of society and all aspects of business. Despite the breadth of that statement, it is still likely an understatement, as people, businesses, and employers had to rethink everything about how they conduct themselves on a day-to-day basis. In business and employment relations in particular, there are a host of issues that would be fitting for an immersive presentation like this one. Wage and hour issues, teleworking arrangements, leave of absence issues, CARES Act compliance, and the statute formerly known as the Families First Coronavirus Response Act. The list goes on and on and on. However, given where things stand as of today, April 20th, 2021, perhaps the most pressing issue for employers is vaccination, and that's where we'll spend our time today, taking a shot at COVID-19, vaccinations, and employment issues. My name is Brian Murphy. I'm a partner in the Labor and Employment Practice Group of Shepherd, Mullen, Richter, and Hampton. Today is actually one of the few occasions since the pandemic began that I find myself in my office in 30 Rock in New York City. While the city is more alive than it has been in past months, it is still far from normal. Pre-pandemic, I would battle throngs of tourists packing the 30 Rock Plaza. Today, I waltzed unobstructed from Grand Central to 30 Rock, passing maybe 10 people the entire time. Now, I mentioned before that there are a variety of employment topics deserving of an entire webinar. Since I cannot cover them all today, and since your time is likely limited, I would like to remind you of a resource that is available to you. The Employer's Guide to COVID-19 and Emerging Workplace Issues. This is a one-of-a-kind resource that I co-authored, which addresses a broad array of employment issues implicated by COVID-19 over the course of 16 chapters and 600 pages. This guide examines the federal response to the pandemic, as well as the approaches of New York, California, and Illinois. We have periodically updated the guide, which is now in its 5th edition since first being published in May 2020, to ensure that our readers have the latest information to guide their efforts with their workforces. It exists in electronic format only and was designed to be user-friendly, and as such is easily navigable through electronic jumps in the table of contents. If you have not yet used the guide, I implore you to take a look. If I understood correctly, the same webpage through which you found the link to this recording also contains a link to the guide, which you are able to view at your convenience. So let's talk about how we got here. On May 15th, 2020, President Trump authorized Operation Warp Speed. This was the federal effort to support the private sector in the development and distribution of multiple COVID vaccine candidates. Operation Warp Speed sought to reduce the typical timeline for development and distribution of a vaccine from 73 months to just 14 months. And given the Food and Drug Administration's Emergency Use Act authorization for 2 vaccines in December 2020 and another in February 2021, and given yesterday's announcement that anyone over age 16 is eligible for a vaccine, Operation Warp Speed has been a historic and undeniable success. The 3 vaccinations currently in use were developed by Pfizer in partnership with BioNTech, Moderna, and Johnson & Johnson. Each were approved by the Food and Drug Administration pursuant to its emergency use authorization powers. Now, what is an EUA power? That is a mechanism designed to facilitate the availability and use of medical countermeasures, such as vaccines, during public health emergencies. Pursuant to an EUA, the FDA may allow the use of unapproved medical products to treat or prevent COVID, provided that there are, quote, no adequate, approved, and available alternatives. The fact that each of these vaccines is available under EUA authorization does not mean they have not been tested. They were each rigorously tested in tens of thousands of study participants to provide the FDA with a high degree of comfort concerning both the safety and effectiveness of each of these vaccines. Now, as for effectiveness, the data continues to evolve, but generally speaking, the estimates are that Pfizer is 95% effective at preventing COVID-19, Moderna is 94% effective, and Johnson & Johnson is 72% effective. Now, we have all heard Dr. Fauci talk about vaccination efforts with the goal of achieving quote unquote herd immunity. Herd immunity is the indirect protection from an infectious disease that happens when a population is immune either through vaccination or immunity developed through previous infection. Right now, the precise percentage of people that must be vaccinated to achieve herd immunity is unknown. It varies from disease to disease. Measles requires 95% of a population to be vaccinated, for example, while polio required just 80%. Dr. Fauci and other experts have estimated that COVID herd immunity will require 70 to 85% of the population to become vaccinated. Now, the US is making great progress towards this goal. As of yesterday, 84 million Americans are fully vaccinated, but it has taken time to get there for a few reasons. The federal government allowed states to determine vaccine eligibility. In most jurisdictions, vaccine eligibility was spread over a 2 to 3 month period, with older Americans and persons with certain medical conditions prioritized first. Likewise, the two most prevalent vaccines, Pfizer and Moderna, require 2 doses 14 days apart. This has presented administrative challenges to achieving vaccination goals. And of course, there are skeptics, anti-vaxxers, and political ideologies that have resulted in some portions of the population to be hesitant to or refuse the vaccination entirely. As of March 2021, 15% of the population in a recent study said that they are unlikely to get a vaccine, and 17% indicated they're at the very least cautious about getting a vaccine. So that's more than 30%. Now, most Americans work or want to work. Employers have therefore been rightly thrust into the spotlight as playing an important role in promoting vaccination of workers and the population at large. Whether out of a sense of obligation to follow orders or a sense of trust that an employer ultimately has the best interests of its employees at heart, employees will often follow the lead of their employers as to many matters, and the research has shown this includes the willingness to receive a COVID-19 vaccine. So what can or should employers do? Well, the first question many employers have is, can we make vaccination mandatory? Can we make it a condition of employment? Can we say you cannot work here without a vaccine, or you cannot return to the office without a vaccine? That question has been answered. Yes, we can make vaccination mandatory for our workers. The Equal Employment Opportunity Commission, the agency charged with administering anti-discrimination laws, including the Americans with Disabilities Act, has made abundantly clear that an employer can legally adopt a mandatory vaccination program. The Occupational Safety and Health Administration, OSHA, the agency charged with monitoring and enforcing workplace safety requirements, has also suggested that mandatory vaccination for COVID-19 is permissible. We've seen this through its prior authorization of mandatory vaccination for hepatitis B and flu vaccines, and there is no expectation that there would be any different treatment afforded to the COVID-19 vaccine. OSHA also separately, under something called the General Duty Clause, requires that employers furnish a reasonably safe work environment. That impliedly suggests that instituting measures to mitigate against the spread of COVID-19 is not only acceptable, but to some extent required. That likely includes mandatory vaccines or the vaccine in general. Another statutory framework to consider is the National Labor Relations Act. It allows for employers to institute mandatory vaccination policies. However, employers in both union and non-union environments need to be aware of a couple of things. In union environments, mandatory vaccination policy would be subject to mandatory bargaining. So it's not something you can simply institute. You certainly have the goal of instituting it, but it's something you're going to have to discuss with the union, particularly as to some of the finer features of the program. Now, in non-union environments, a lot of people often expect that the NLRA really has no application, but that's untrue. In non-union environments, the NLRA still protects workers when they engage in what's called protected and concerted activity. That is when they mobilize around an issue on a collective or group basis. Now, opposition to or support for a vaccination program is just the kind of issue that tends to get workers to coalesce to engage in protected and concerted activity. Beyond statutory authority, while it has not happened yet and might never happen, going forward, courts in the past have upheld the ability of state and federal government to require vaccination. And I offer just this quote. I offer this quote from an old case dealing with the smallpox. In every well-ordered society charged with the duty of conserving the safety of its members, the rights of the individual in respect of his liberty may at times, under the pressure of greater dangers, be subjected to such restraint to be enforced by reasonable regulations as the safety of the general public may demand. Now, again, we've not seen any states or the federal government require vaccination. I think it's a long shot that that would happen. However, there is judicial authority to support the state or government's ability to do so. So while we've answered the question of whether it can be mandatory, the follow-on question is, of course, should it be mandatory? There are a number of factors that may influence an employer's decision in this regard. First, as I just mentioned, a mandatory vaccination requirement is fertile ground for protected and concerted activity and union organizing efforts. We've already seen unions become active in using this issue as a symbol to get workers interested in organizing and forming a union. That activity will likely only increase under the Biden administration and the Biden administration's elimination of some hurdles to union organizing activity and election. Second, is a mandatory policy necessary given the physical realities of the workplace? Is the population working outdoors where the threat of COVID is lessened? Due to the nature of your operations, naturally have workers physically distance themselves? Have you transitioned to a teleworking environment or remote environment going forward such that there is no threat of infection in the workplace? If the answers to some or all of those questions are yes, mandatory vaccination programs seem less and less necessary. Third, employers have to consider the competing views of their workforce, both pro-vaccination and anti-vaccination. You will have some who refuse because of their personal beliefs about the safety of vaccines or their objection to an edict that infringes on their personal choice. You have some who are ardently in favor of vaccines who will refuse to report to work out of safety concerns arising from unvaccinated segments of the workforce. Employers need to have their finger on the pulse of their workforce and the views of their workforce before announcing a position between mandatory and encouraged vaccination. Fourth, as a practical matter, I think employers need to consider what they do if they implement a mandatory policy and a worker or group of worker refuses to comply. One or two employees will not present much of an issue, but if 30% of the workforce, approximately that same estimate of folks that are wary of or will refuse to get the vaccine, what if that segment of the population refuses to comply with the mandatory policy? Are we as employers prepared to discipline a large group? Can our operations continue if we suspend or even terminate workers who refuse to comply? Again, that's where it's key to having an understanding of the pulse of the workforce and their views before making a final decision in this regard. And fifth for my purposes, but I'm sure there are other considerations, you do have to consider the public expectations as to the vaccination status of your workforce. An obvious example would be healthcare workers. The public expects those charged with providing medical health care to have been vaccinated. So you should consider the extent to which the nature of your operations requires face-to-face interaction with the public and determine to what extent a failure to require vaccination would subject the company to public scrutiny or public backlash. Now, we're going to discuss some of the legal pitfalls, particularly in the employment area, associated with vaccination in more detail, but I do want to emphasize now that all of the considerations that I will run to, for the most part, will ultimately be present and something that needs to be dealt with, whether you as an employer adopt a mandatory or encouraged vaccination program. So employers taking either approach must be equally cautious, as we will discuss in a moment. Now, if you are not inclined to mandate vaccination for some of the reasons we discussed, how should you go about encouraging vaccination? Well, messaging will differ from organization to organization, but there are a few shared themes you may find useful. Employees respond well to incentives, whether that be time off, a bonus, or a gift card. Consider what perks you can provide to encourage your workforce to become vaccinated. Employees also appreciate information. With COVID, the problem is often proven to be the availability of too much information from sources that often conflict, which leads to confusion and which sows doubt as to a variety of factors implicated by COVID, including vaccinations. Employees will be appreciative and often trustful of information concerning vaccinations assembled by their employers on their behalves. The view effectively is that the employer has taken the laboring oar and waded through the morass of information and presented that which has been confirmed as reliable to their employees. And that's the expectation of employees. Now, while it's less of a concern now, given the widespread availability of vaccines, employers for a time, and maybe continuing in the future, also had to consider how they assist employees with obtaining vaccines. Again, now they're so widespread that it's not as much of an issue, but early on in 2021, there were concerns about limited supplies. So an employer can certainly incentivize employees or encourage employees and develop a sense of trust with employees on the issue by providing resources for how and where to schedule an appointment, for instance, or contracting with a provider even in some circumstances to provide vaccinations on site. Those are just two possibilities. Lastly, employers should consider the financial implications of vaccination and whether they have the power to offset or lessen the cost to employees. Employers can outright offer to cover the cost to the extent the insurance does not already do so. Employers can also consider providing paid time off as the carrot to entice an employee to obtain a vaccine. In fact, in some states, New York, where I sit, that's already happened by legislative fiat. In New York, employers are obligated to pay employees for up to 4 hours for each shot at their regular rate of pay. To the extent an employer is not under statutory authority to do so, again, that could be a nice voluntary incentive to provide employees. There are plenty of other tools available. These are just a few for employers who wish to incentivize their workforce to get vaccinated. If you're looking for further information on this topic, McKinsey & Company published an excellent article on April 9th of this year called Getting to Work, Employers' Role in COVID Vaccination. It's available online. I would suggest giving it a read. Again, it's really provides a lot of historical data and just current studies as well, designed to help employers understand how best to speak with their employees and provide them with resources to encourage vaccination. Now, let's talk about potential pitfalls for employers under the various equal employment opportunity laws that may come into play, whether you mandate a vaccine or whether you simply encourage a vaccine for your employees. These EEO laws, equal employment opportunity laws, provide the paths by which an employee can potentially object to or refuse a vaccine and the obligations of employers in response. These laws also govern the manner in which employers can request vaccinations or proof of vaccinations or seek information in connection with encouraged or mandated vaccinations. The EEOC is the agency charged with administering the protections created under the various EEO laws. The pandemic and the potential for vaccination implicates three of those laws. First, the Americans with Disabilities Act, the ADA, which affords protections to workers with disabilities and regulates disability-related inquiries and medical exams. As a general matter, it prohibits employers from excluding qualified persons from the workplace unless they pose a quote-unquote direct threat to the safety or health of others, which we will explore in more detail in a few moments. The ADA also requires that employers provide qualified workers with reasonable accommodations that would allow those workers to perform their job to the extent the accommodation does not impose an undue hardship on the employer. Again, we'll explore this in greater detail as well. Second, we have Title VII of the Civil Rights Act. Title VII prohibits discrimination on the basis of religion, among other prohibited bases. An issue less frequently encountered than disability discrimination, but related to that concept, is discrimination and the necessity of providing an accommodation to a person who holds a sincere religious belief. In the context of vaccinations, employees may object to receiving a vaccination on the grounds that it offends a tenet of their religion or one of their religious beliefs. Those religious grounds may take many shapes depending on the religious beliefs of employees, but are often rooted in the materials, including organic matter that is often included in the vaccination, in the delivery vehicle for the vaccination. And third, we have the Genetic Information Non-Discrimination Act. This law, infrequently encountered by employers, generally prohibits employers from seeking information about an employee's genetics, their family's genetics, or family illness. Now, how do we know that these are the three primary EEO laws that employers must contend with in connection with policies and approaches to vaccination? Well, because the EEOC told us so in updated guidance published on December 16, 2020. Entitled What You Should Know About COVID-19 and the ADA and Other EEO Laws, the EEOC first published guidance in March 2020, addressing some of the then novel and relevant concerns around medical inquiries, symptom screening, and testing. The December 2020 update added 9 question and answers immediately on the heels of the EUA approval of the Pfizer and Moderna vaccine. And it's this guidance that I will now begin to explore in detail. Let's start with the ADA, the Americans with Disabilities Act. Contrary to what many might expect, the EEOC announced that a vaccination is not a medical exam under the ADA. A medical exam seeks information about an individual, medical information. A vaccination, in contrast, and according to the EEOC, does not seek anything from an individual. The EEOC said that is the case whether the vaccine is administered by the employee's healthcare provider, a third-party contractor of an employer, or the employer itself. Why is that so important? Why is that a critical concept? Because this restriction on medical examinations applies to all employees and not just those with a disability. And because a medical examination in the ordinary course is only permitted where it is, quote, job-related and consistent with business necessity. That is often a complex and fact-specific inquiry, and one that would have to be undertaken for all employees, given the restriction on medical examination of all employees. Thus, the EEOC has effectively loosened the reins, giving employers the freedom to require or encourage vaccination without having to jump through the analytical hoops that ordinarily would be required. It reflects the balancing that the EEOC is doing in administering its laws, but recognizing that employers will play a vital role in resolving the current health crisis. Now, while a requirement for a vaccination itself is not independently problematic under the ADA as a result, there are still ADA pitfalls in the process of vaccination. Specifically, pre-screening questions, those asked to determine eligibility or issues impacting whether someone should receive a vaccine, likely constitute disability-related inquiries under the ADA. Again, that's a term of art under the ADA, disability-related inquiries. Because they are disability-related inquiries, employers must demonstrate that the screening inquiries are, quote, job-related and consistent with business necessity. What does that mean? An employer could not take action against an employee for refusing to answer screening questions, could not exclude the employee from the work site for failing to answer questions and therefore not receiving a vaccine, unless the employer could demonstrate by objective evidence that the employee would pose a direct threat to the workplace. It's confusing. Who wants to deal with that? Thankfully, the EEOC has offered an easy fix. Employers should not administer the vaccine themselves or should not contract with a third party to administer the vaccine on their behalf. An employee's healthcare provider can ask these questions without implicating the Americans with Disabilities Act. An employer cannot. A third-party vendor of an employer cannot. The ADA would be implicated. Somewhat related, requesting proof of the vaccination does not have ADA implications either. So to the extent you as an employer are going to require or encourage vaccination, do not administer it yourself or contract with a third party to do so and save yourself the trouble. I should clarify, however, that while requesting proof of a vaccination does not in and of itself have ADA implications, follow-up questions may and should be avoided. For example, asking an employee why they did not receive a vaccine may elicit information about that person's disability, such that the question would have to be, quote, job-related and consistent with business necessity. That would again require an employer to demonstrate that it has objective evidence that this specific unvaccinated employee poses a direct threat to the workforce. Avoid the headache, don't ask the questions. Mandatory or encouraged vaccination programs, leave it to the employee's healthcare provider. Now, whereas the information I just covered applies to both mandatory and encouraged vaccination policies, what I am about to speak to concerns mandatory vaccination policies only. That is, how do we respond to an employee who refuses a vaccination? If it is simply a refusal that is not tethered to a medical condition of an employee, or as we will discuss, a religious belief of an employee, we can exclude the employee from the workplace. The EEO laws do not prevent employers from imposing what are called qualification standards for working or reporting to a work site. We should, of course, ensure that any worker refusing the vaccine does not have other protections. For example, it would be unlawful to exclude or terminate all female employees who refuse a vaccine while not holding male employees to the same standard. That's an obviously extreme example, but we don't want to be making those slicing and dicing the workforce in that way when it comes to treatment for refusing a vaccine. Generally speaking, putting that aside, we can respond to a non-medical and non-religious refusal to receive a vaccine as we see appropriate. If, however, the vaccination requirement would result in the exclusion of a disabled employee from the worksite because of their inability to receive a vaccination, the analysis does get more complex. Employers would have to show that the unvaccinated employee would again pose a direct threat or due to a significant risk of substantial harm to the health or safety of the individual or others that cannot be reduced by a reasonable accommodation. The ADA requires that this analysis be individualized. We cannot simply say the unvaccinated employee will expose others without more. The law requires us to consider a number of factors in determining whether that standard is met. So in determining whether someone poses a direct threat, we have to consider 1, the duration of the risk, 2, the nature or severity of potential harm, 3, the likelihood of potential harm, 4, the imminence of potential harm. Now, 3 of those 4 factors are likely satisfied in almost all situations, given the pandemic, the ease of transmission, and the potential negative health outcomes. However, the 3rd factor, the likelihood of potential harm, may impact the conclusion that an employee poses a direct threat. A remote worker who refuses to be vaccinated is not likely to cause harm. A worker who is employed outdoors who refuses to be vaccinated is less of a threat to other workers. A worker who dons PPE as part of their responsibilities, PPE, again, personal protective equipment, a worker who dons PPE as part of their responsibilities is not likely to cause harm. So we have to, while we have to evaluate all those factors in the circumstance of an employee refusing a vaccine for disability-related reasons, it's really the likelihood of potential harm factor that deserves the most attention. But what do we do if we conclude there is a direct threat? Can we exclude the employee from the worksite then? Well, the answer depends on whether a reasonable accommodation exists that would eliminate or reduce the risk so that the unvaccinated employee no longer poses a direct threat. What is a reasonable accommodation in this circumstance? Well, let's start more generally. What is a reasonable accommodation? It is a modification or adjustment of the work environment or the manner in which a position is performed to enable a qualified individual with a disability to perform the essential functions of that position. That's the definition under the statute. Now, in the context of COVID and the refusal to or inability to receive a vaccine, what does that mean? What kind of reasonable accommodations need to be considered for those folks? Well, perhaps some of the measures that employers adopted prior to the advent of COVID-19. Prior to the advent of the vaccines to prevent COVID-19. For example, before December 2020 and continuing to this day, many employers were requiring the use of masks, PPE, and social distancing. Many employers were requiring employees prior to reporting to the worksite to submit to screening or testing protocols. Leaves of absence were granted for workers who were exposed to the virus. Most prominently, of course, is allowing workers to work remotely, telecommute as an accommodation. It is difficult, frankly, to say if we're met by an employee who cannot become vaccinated for disability-related reasons, that we can't offer them the accommodation of working remotely where they don't pose a direct threat. If, in fact, from March 2020 through December 2020 or to the present, they were able to perform their duties remotely. Now, just another resource, employers faced with an accommodation request, because I certainly can't predict all the various circumstances in which they might arise, might want to consult a resource available online called the Job Accommodation Network. It's a free resource sponsored by the U.S. Office of Disability Employment Policy. The EEOC has also endorsed it in its vaccine guidance in December, and it provides a variety of potential accommodations organized by disability, the specific limitation the employee has, such as an inability to become vaccinated, and other topics. Now, if one of these accommodations will reduce the risk posed by an unvaccinated employee such that the employee does not pose a direct threat, the employee cannot be excluded from the worksite. This reasonable accommodation process for vaccine refusals is generally the same as reasonable accommodations in other contexts. Thus, managers and supervisors should be on the lookout for such requests and know who in the organization requests should be referred to. Employers must remember that they are required to be flexible in exploring accommodations, and that the process must be interactive such that the opinion of the employee and their views on an appropriate accommodation are duly considered. Likewise, employers are afforded the opportunity to consider whether whether an accommodation would impose an undue burden or an undue hardship on the organization. Undue hardship means significant difficulty or expense to the employer, and that can take many forms. Accommodations that are extensive, disruptive, or would alter the nature of the business operations to more than a de minimis degree may present an undue hardship that would not require an accommodation to be granted. It is ultimately a balancing act, but it's a necessary one. I would just offer a word of caution. Even if an employer cannot provide a reasonable accommodation that eliminates the threat posed by an unvaccinated employee, but still allows for the essential functions of the position to be performed, or an accommodation that would impose an undue hardship, employers may exclude an employee from the work site, which should not automatically move to terminate. Employees may have other protections under other EEO laws or state and city laws. So we should still proceed very cautiously in this sphere. As I said at the outset, in the case of a mandatory vaccination policy, disability-related reasons will not be the only reason you will hear for an inability or refusal to be vaccinated. Objections based upon religious beliefs or religious practices will certainly be raised, and our obligations in that respect are governed by Title VII of the Civil Rights Act. Title VII requires us to reasonably accommodate an employee's, quote, sincerely held religious beliefs, observances, and practices when requested, unless accommodation would impose an undue hardship on business operations. This requires us to consider a few things when faced with an employee objecting to a vaccination because of a religious belief. First, is the belief religious? EEOC says that religion includes, quote, moral and ethical beliefs as to right and wrong that are sincerely held with the strength of traditional religious views. That is, the belief must concern ultimate ideas about life, purpose, and death. The religion, importantly, need not be widely practiced. Religious beliefs do not, however, include social, political, medical, or economic philosophies or personal preferences. Objections that vaccines are tracking devices or that vaccines are a political tool of the left or the right will not fly. But I'm sure as employers, you will certainly hear those excuses, and just be aware they do not qualify. That being said, the line on this is admittedly very gray. Just by way of one example, a recent case arising in federal court in North Carolina, 3 employees objected to receiving a mandatory flu vaccine on religious grounds. The reasons that these employees offered included, quote, our bodies are our temples and God gave us dominion over our bodies. Quote, followers of her religion are healed by plants, fruits, and grains. And quote, injecting chemicals and disease into the body is contrary to God's intention. Now, the court held that each of those to qualify as religious reasons supporting refusal of the flu vaccine. So the first thing we're considering is the belief religious, triggering Title VII? The second analytical thing is the religious belief sincerely held? The EEOC takes a position that employers should generally not challenge the sincerity of a professed religious belief or practice. However, if objective evidence is available, employers would be warranted in requesting further information. Has the employee behaved in a manner inconsistent with the professed belief? Is the accommodation sought a particularly desirable benefit that would be sought for secular, non-religious reasons? Is the timing suspicious? For example, did the request for time off or a leave of absence follow a similar request that was made and rejected for non-religious reasons? Any other objective reason to believe that the accommodation is not sought for legitimate reasons. Again, the directive from the EEOC is to tread carefully here. The presumption is that it's sincerely held. The belief is sincerely held, but be aware, be on the lookout for folks who are seeking just to take advantage of this aspect of the law. Now, third, even if it is a religious belief, and even if it is a sincerely held religious belief, we do get to consider whether the accommodation requested, here an exemption from a mandatory vaccine requirement, would impose an undue hardship. The standard in the context of a religious objection under Title VII is much lower than that under the ADA in the context of a disability-related objection. Anything that would impose more than a, quote, de minimis cost or burden to the employer is too much and dispenses with the employer's need to accommodate that employee's belief. Thus, employers need to consider and should consider the cost of the accommodation in relation to the employer's size, the number of employees that might need the accommodation, the extent to which the accommodation diminishes efficiency of operations, whether the accommodation impairs workplace safety, whether it burdens other employees, and whether that accommodation increases legal risks for employers. Any one of those might tip the scales in favor of the requested accommodation and exemption from the vaccination requirement, might tip the scales in favor of presenting an undue hardship such that we need not accommodate it. Now, as under the Americans with Disabilities Act, the employee and employee objecting on those grounds should not automatically be terminated without first considering other potentially applicable protections that the employee might have under federal, state, city law that would allow them to avoid discipline or otherwise continue to hold their job if termination was being considered. So again, tread lightly. The final big EEO law implicated is the Genetic Information Non-Discrimination Act of 2008. It's a federal law that employers, frankly, do not confront all that frequently. Of course, COVID has changed things. This law prohibits unauthorized access to genetic information and discrimination on the basis of genetic traits. The primary concern behind the law was that certain genetic traits are associated with certain demographic portions of the population, and thus could serve as an end around other protections embedded in Title VII, which prohibits discrimination on the basis of national origin, race, religion, creed, etc. In its guidance, the December 2020 guidance that I mentioned before, the EEOC confirmed that the administration of a vaccine or a requirement that the employee receive a vaccine does not alone implicate the Genetic Information Non-Discrimination Act, because it does not involve the use of genetic information to make decisions or involve the acquisition of genetic information. The EEOC also confirmed that the Genetic Information Non-Discrimination Act is not implicated by virtue of the fact that at least 2 of the 3 vaccines are what are called mRNA vaccines, because of its conclusion that the mRNA vaccines do not interact with DNA in any way, and that the mRNA never enters the nucleus of the cell, which is where DNA is kept. As such, because the vaccine does not modify a recipient's genetic makeup, requiring an employee to get the vaccine as a condition of employment is not an unlawful infringement on that genetic information or on that individual's genetic informational rights. Now, as under the ADA, however, while the administration of a vaccine or requirement of proof of vaccination does not independently implicate the Genetic Information Non-Discrimination Act, pre-screening questions may. For example, information about genetic tests employee has received, information about the genetic tests of a family member, or information about family histories of illness and disease. These are the types of questions that are often asked before administering any type of medical intervention. So of course, vaccines are included in that as well. These questions will elicit genetic information that is protected by the Genetic Information Non-Discrimination Act. Again, easy solution. Do not administer or contract with a third party to administer vaccines on your organization's behalf. It is not a Genetic Information Non-Discrimination Act violation for an employee's healthcare provider to ask such questions. So my advice is simply steer clear. Mandatory or encouraged vaccination programs, do not administer them and do not contract with a third party to do so. Well, there's always exceptions to the rule. As I said, simply requesting proof of a vaccination does not directly implicate the Genetic Information Non-Discrimination Act. However, the Genetic Information Non-Discrimination Act does prohibit employers from, quote, requesting, requiring, or purchasing genetic information with respect to an employee or a family member of an employee. Proof of vaccination, the document itself may include such information, which would potentially be turned over to the employer. I'm sure if you're on Facebook, you've seen a lot of people after receiving their vaccine held up their vaccination card to prove to the world and their friends and family that they've received the vaccine. There is information on that card that is implicated by the Genetic Information Non-Discrimination Act. The law, however, provides a safe harbor for inadvertent acquisitions of such information. The law provides model language, which you can see on this slide, that guards against inadvertent disclosure, in which the EEOC says will provide an employer with a defense to a claim under the law if an employee provides proof of vaccination which ultimately includes that genetic information. Accordingly, if you as an employer are requiring proof of vaccination, be sure to include this disclosure in writing to your employees as part of that request. Now, given the challenges that vaccination presents, whether mandatory or encouraged, it is helpful to recap rights and responsibilities of employers around protocols for returning to work before the advent of the vaccines. Each of these still remain feasible or infeasible, as the case may be, in 2021. I emphasize, however, that permissible practices identified on this slide are only permissible for employees working on site and not for remote employees. The quote, job-related and consistent with business necessity standard that prompted the EEOC to authorize each of these steps in the early days of the pandemic falls away for remote employees that are not physically reporting to the worksite. So we can, again, as alternatives or together with any vaccination programs, we can still do symptom screening. We can still ask about COVID diagnosis and test results. We can still take temperatures. We can still require COVID tests. We can still require fitness for duty certificates, and we can still refuse entry to the worksite for workers who fail to comply with whatever protocols we have instituted in this regard. However, what can we not do? We cannot use antibody tests. We cannot ask about family member illness, and we cannot preemptively exclude at-risk workers, particularly those over 65 or those who are pregnant. Again, just to emphasize, each of these can be used or not used in tandem with the vaccination program or as an alternative to a vaccination program, mandatory or encouraged, should that be the preference of the organization. Now, just to address one, I shouldn't call it a small area of concern, but ultimately a small area of law in the fabric that makes up the COVID employment considerations. In the context of a vaccine, what happens if an employee has an adverse reaction to a vaccine? Because this does happen. Vaccines can cause injuries. It's not theories that anti-vaccination proponents are spouting that are rooted in pure speculation. It does happen on occasion. Johnson & Johnson, for instance, has recently been in the news with suspicions, I think as of now unsubstantiated, of a potential link between the Johnson & Johnson vaccine and blood clots. So the question naturally arises among employers: if we encourage or require vaccination, an employee has an adverse reaction to that vaccination, what is our responsibility? Or more fittingly, what is our liability? What is our exposure? Well, helpfully, workers' compensation should serve as an injured employee's exclusive remedy in the event of a vaccine injury. Generally speaking, workers' compensation provides an employee's sole remedy for injuries arising out of or occurring during the course of employment. We fully expect that a vaccination program that is either mandated or encouraged will have, in the view of the law, a sufficient nexus with what the employee is doing to trigger workers' compensation protections. Workers' compensation is a creature of state law. So to the extent you have any questions in your local jurisdiction, you should, of course, consult authorities that would speak to what the contours of that are in your jurisdiction. And you might be able to answer those questions directly with your insurance provider. But generally speaking, the expectation is that an injury or adverse reaction to a vaccine that is required or mandated by an employer or encouraged by an employer would be covered by workers' comp, such that the employee would not have a right of action to sue the employee for that. To sue the employer for that adverse action. Even if that were not the case, however, for an injured employee to pursue a claim as against an employer in this regard, the employee would somehow have to demonstrate that an employer was negligent. That would be the basis for the claim against the employer. Negligence, gross negligence, something to that effect. If the vaccine that we are encouraging use of or requiring use of is FDA approved as the 3R pursuant to the EUA authorization, and it's administered by a qualified third party, it is difficult to see a path forward to an employee to somehow articulate a claim that the employer was negligent in some respect. So I think while it's rightfully front of mind for a lot of employers, ultimately the concern is a practical matter should be lessened. Now I'm going to finish up over the next two slides with a discussion about how to implement your chosen stance, whether it be a mandatory or encouraged vaccination program. Care must really be taken here because, as with everything, frankly, the devil often is in the details. First, employers need to crystallize the message that will accompany their approach to the workforce, the message that will be delivered to the workforce. Employers will need to think about and understand their workforce and their workforce's competing views on the safety of vaccines or the impact their political beliefs may have on their willingness to be vaccinated. Employers will need to consider the nature of the services they provide. If the employer is public-facing, the company is public-facing, servicing the public, that should serve as a centerpiece of the employer's communication because employees can gravitate towards that objective fact. It is an understandable rationale for mandating or encouraging vaccination. Employers certainly need to understand that in terms of messaging, one size does not fit all. That applies across employers, but generally not within, meaning from one employer to the next, a different message may be more effective for the constituent workforces. However, within a single employer, we generally expect and want a unified message that applies to all workers, irrespective of position, irrespective of standing within the company, on equal grounds. Now, while some distinctions can be drawn among the workforce, provided they're done for non-discriminatory reasons, vaccination is a lightning rod in some circles, some geographies, such that absent compelling reasons, such as a segment of the workforce who do not have to report to work because of their responsibilities, we should implement the same policy and have it apply to all employees and message it as such. Employers would also be best served in their messaging to avoid politicization of the issue. Again, it's a lightning rod, so it's quite easy to do that. The best course of action is to just arrive at a refrain such as vaccination, whether encouraged or mandatory, is the quote best path back to normalcy, and stick with that. That should ultimately become the mantra of the employer when communicating their vaccination policy. And lastly, employees will look to leadership to gain confidence in the selected vaccination approach. Leaders in the organization who are supporting the message, who are behind the message, who are publicizing the message, should be ready to publicize their own vaccination experiences and openly discuss it. Employees are more apt to follow in the footsteps of those that lead the organization, particularly if they know that the leaders of the organization are doing exactly as they have asked the employees to do. Lastly, we have crafting an appropriate policy. An employer needs to craft a policy in writing that reflects the message that we just discussed, however it's arrived at. But that policy should contain details around what the actual vaccination program will look like. So as I just mentioned, the messaging should be a prominent feature of that written policy. If we are drawing distinctions among our workers, against my prior advice, if we're ultimately doing that, we should be upfront about it and explain why. We do not, some segments of workers feeling like they are obligated to do something that others were not for arbitrary reasons. So we should commit to the reasons, the objective reasons why that policy decision has been made. And of course, we should be sure, based upon keeping our finger on the pulse of our workforce, that that reason that is offered will be something that is acceptable and rational to our workers. We should reduce to writing our expectations regarding how someone will be vaccinated or what will be expected from them. In that regard, whether it would be an employer-administered program, a third-party administered program contracted with the employer, or the employee's healthcare provider, the how of them getting the vaccine, as well as what proof, what documentary form might we require. Will we actually wish to look at the card, despite the concerns I raised about the Genetic Non-Discrimination Information Act, or will we simply require an employee to commit in writing, for example, certify in writing that they've received the full inoculation? We should also as well put in writing our approach with regard to religious and disability-related accommodation requests, because you will get them. Inevitably, if you have more than, I'd say, 4 or 5 employees, chances are someone will object in some regard to receiving the vaccine. So we should be upfront about what our policy around accommodations will be. We want to make clear that we will have in each of those instances an interactive dialogue with the employee, but at the same time that we explain that we cannot provide an accommodation that would result in the employee presenting a threat to our workforce or otherwise creating an undue burden in the workplace. And lastly, and perhaps most importantly, we should detail the consequences of an employee's failure to follow our policy. We do not suggest, and I do not suggest, automatic termination if someone refuses a vaccine in the context of a mandatory vaccination program, given the bevy of legitimate reasons someone may have for objecting to a vaccine. However, we should highlight that unsupported or illegitimate reasons for refusing a vaccine and refusing to comply with our policy in this regard may warrant discipline up to and including termination of employment. Now, I will conclude with what amounts to an acknowledgement of the difficult position you as employers are each in. On the one hand, employers are thrust to the forefront of the conversation and the effort to maximize vaccination numbers. That's being foisted upon employers, whether they like it or not. Despite having that responsibility thrust upon them, the statutory framework within which employers must operate makes it difficult for employers to carry out that charge without opening themselves up to potential liability for missteps. My hope is that this presentation will assist you in navigating the potential landmines and that you are able to resume operations in an environment where concerns about COVID are a thing of the past. Now, this format did not allow for questions. However, as you can see on the slide here, this is my email address. I would be happy to receive any commentary or thoughts on this program, and I would be happy to address any questions that you ultimately have around this really important issue. So with that said, I'm very appreciative of your time. Don't hesitate to reach out, and good luck moving forward. Stay safe.